Presbyterian group and some others, who were actually in their brief very, very critical of the 30-year-old decision I just mentioned. And then we had a brief of religious minority groups, including Hindu groups, Muslim groups, Jewish groups, Unitarian groups, et cetera, talking about the unique pressures that members of minority faiths have faced as a result of legislative prayer practices. And also the flip side that when members of minority faiths are given opportunities to deliver legislative prayer, they are often met with extreme hostility by people in the majority who are objecting to non-Christian prayer. We also had, the town submitted a brief, there's a brief on file on the town's behalf by a number of members of Congress. I believe they were all Republicans and all Christians, saying what the town's doing is fine. We actually had a brief of other members of Congress, some from a variety of different faiths, saying, wait a minute, first of all, this is very different than Congress, and second, even in Congress, the guest chaplains are given guidelines being asked to stay away from sectarian controversies precisely because there's increasing diversity. So that was some of them. There were a number of other ones. I'm trying to think off the top of my head. There was the American Civil Liberties Union and the Anti-Defamation League did a brief. There was a brief on behalf of a couple of constitutional law professors addressing the argument that the town was making that this is actually the free speech of the guest clergy and that can't be touched at all, and then there were a handful of others. So it was a pretty, there's a total of probably, between both sides, there's probably like 3 dozen friend of the court briefs, which is actually pretty common in a case like this. Yes?
I have a question. In your opinion, if the court rules in your favor, which I certainly hope it does, what cases can you foresee springboarding off of this one? And is that kind of foreshadowing acting in your favor or against you right now if the court is kind of considering the future in terms of the ruling?
So I'm not going to make any prediction as to what way they may or may not come out. It depends in part what the decision is. So if, for instance, they say that in this situation the prayers are unduly coercive, then the next set of cases would be, maybe if certain steps are taken to alleviate the coercion, it's still too coercive. If the court says the town needs to take greater efforts to increase the diversity of the prayer givers, then you might have the next case, like maybe it's more diverse, but it's not as monolithic here, but it's not totally diverse. Like, is that enough? So those are 2 possible ways. On the flip side, if the town or the government's argument is accepted that courts can't look at the content unless the prayers are explicitly proselytizing or disparaging, then you have the question of well, what's proselytizing or disparaging? Does it have to be converts where you will go to hell, or does it need to be, can it be more subtle? I think the only way you don't get follow-on cases is if they say no prayers whatsoever, or if they say absolutely anything goes. And otherwise, you get questions centered on, has the coercion been alleviated? Are these prayers sufficiently inclusive? Is the lineup of prayer givers sufficiently diverse? Or some combination of those? Yes?
From my perspective, the 30-year-old case is all wrong, which makes me wonder about your thoughts on whether it, either in this case or down the road, can be restricted to its premise that the reason for allowing these prayers in the first place is so that the legislature can be ministered to.
Right.
And if that's the real reason for these prayers, which I personally get, but if that's the justification, has there been an attempt, has there been an argument made that if the purpose is ministering, these bodies can go off to a little room with their minister be ministered to without involving the public in everything.
Right. So, I mean, there was, I think, a wide spectrum of arguments talking about the rationale for that decision and how it might be limited. You know, we said, we're not asking you to overrule it, but the way you apply it has to take into account the practicalities of the local level. You had the brief I mentioned a moment ago, the Baptist Joint Committee brief, which basically said, marsh stops at the state level, local governments can have no prayer. State and Congress can do it, but local governments can't. And then you had the American Civil Liberties Union brief, which said marsh should be overruled. So you had sort of a full spectrum, a full menu of people like giving the court a lot of different ways to overrule marsh, limit marsh to its facts, allow marsh but apply it with sensitivity towards differences. So, you know, I think does the Supreme Court want to limit marsh? You know, I think that's a question. Justice Scalia in particular was very, as he often is in cases like this, was very emphatic. It's like, look, there's an interest on the other side. You know, the members of this board, you know, they have an interest in, you know, seeking this divine guidance at the meetings themselves, and you shouldn't be able to limit that. So, you know, I think Justice Scalia, for instance, yeah, like, I mean, right. So, I mean, you know, there's actually there was another thing going on here, which was actually a little interesting, and it could cut in one of two ways, one for us, one against us, which was, so the Marsh decision from 30 years ago was very much a like historical, this is what Congress did, if Congress did it, it's okay. And it really has been treated by the lower courts as kind of an exception to, it's kind of a historically based exception to the normal rules. There were questions at oral argument about that, like that rationale. So Justice Kennedy asked the town's lawyer, you know, is your argument basically that like this is just a historical anomaly that legislatures are treated differently? Which, again, you could read in two ways. One way could be you can't possibly justify what you're doing with resort to history. The other way could be it's fine for you to do it and it's fine for any other body to do it, right? So Chief Justice Roberts had a variation on that question, which was, again, it was to the town, and this keys off one of the questions from a moment ago, which is, isn't there a difference between something that has been going on for 200 plus years and something that started 10 years ago? So in other words, even if it was okay back when they were doing it in 1789, does that mean you can start it up in 1999 with the same protection? So I think it's fair to say that there were a number of justices, most of whom, maybe all of whom, I'm not sure that any of the justices currently on the court were on the court when Marsh was decided. In fact, I'm pretty sure that none of them were. And so you have a decision that none of those justices wrote or joined. You have a number of different justices with a number of strong opinions about the separation of church and state, religion, speech. So I think there is some inclination to look at the logic of that decision and how it applies here, but that doesn't necessarily mean greater protection for church-state separation either. It could actually, the flip side is it could mean that Marsh and the legislature no longer becomes an exception, and that if the legislature can do it, other entities can do it. And there is actually in the town's brief, although they did spend most of it talking about Marsh and the legislative prayer, there's this 5-page section in their brief in which they're talking about like the judiciary, the executive, suggesting that this would be appropriate for other branches. They moved off of it a little in their reply brief, and then Justice Ginsburg actually asked the lawyer straight up, like, there's some language in your brief that suggests all three branches. Is that what you're saying? And he said, no, it's a legislative branch. So it's unclear, but I think there was certainly some scrutiny of that decision, but that doesn't necessarily mean it's going to be overruled or even limited. It's possible it gets expanded. So, yes.
On the Scalia point of divine guidance, I don't know if it's been studied of the efficiency of government or clergy-led prayer in producing positive results. I know Detroit just went bankrupt.
Right.
They had city council prayer.
Right.
And I know some cities, I don't think there's been any proof anybody that
interestingly enough, I gave a speech about this case back in June in Rochester to the New York Civil Liberties Union up in Rochester. And so people in the audience there, many of them lived in Greece, had been following the case closely, and so they knew the local politics there very well. And there actually have been a number of sort of scandals in Greece in the last couple of years involving like corruption in the police department, and then the mayor, the outgoing mayor had an affair with a woman whose husband died, or whose husband was killed by their son. This was like, and so I got a question. In fact, the final question I got there was like, given all these scandals that have taken place, doesn't it suggest that the prayer practice is actually harmed rather than helped? So I, of course, just as a lawyer, said no comment. But I do think I think something like that is obviously very difficult to measure. I think the theory, if you were to state the theory, the theory underlying it sort of charitably, is that, look, these guys are doing the best they can and they have the right to seek divine guidance at their meeting when they're going to be making decisions. Like I said,
clergy's not divine.
well, right, exactly. Right. And I think that's right. I mean, if you think about it, like the cost to the members of the board of seeking that divine guidance in the back room before they come out, versus the cost imposed on people in the audience who are forced and pressured and perhaps forced to participate in something at their one chance to petition their local body. I think the scales aren't sort of equally weighted there, but in any event, that's sort of the rationale, and so that's the rationale. And I think it's fair to say that rationale is unlikely to fall by the wayside, barring a change in the composition of the Supreme Court. Yes.
And what is town council doing pending the Supreme Court's decision?
They well. So here's what happens. They're continuing to do their practices. So the way this case unfolded was that so we brought our lawsuit in the trial court. Trial court ruled for the town, and so our case was dismissed. We appealed. The appeals court said the trial court not only should not have dismissed our case, but actually he should have ruled for us. The Court of Appeals then sent the case back to the trial court for the crafting of an injunction, basically a remedy saying, putting guidelines for what the town can and can't do. But before that happened, the Supreme Court heard the case. So there's been no remedial procedures yet. There's no court order limiting what the town can do right now. So they have been doing what they've been doing. I think, again, in the couple of years since the formal discovery record closed, I think, again, they had like 4 instances of non-Christian prayers, leading Justice Sotomayor in the town's lawyer's rebuttal to be like, wait, so you had 4 in 4 years, that's 1 a year, and you guys meet once a month, so it's basically been unchanged while this has been going on. Yes.
Can you comment on what effect this case has had on the citizens in town?
I don't know to what extent it's had an effect recently. When our clients were initially voicing their objections and when they initially filed suit, there was a huge amount of blowback. Our clients got threats and hate mail and sort of the full gamut. I don't know that it's been like, just because it's been going on for so long, I don't know that I don't live there, but my sense is the town has not been in like a constant state of uproar since this happened, but there was certainly a lot of blowback and agitation in 2007, 2008 when our clients first raised their objections when we first filed the lawsuit.
I think in a lot of these cases, the official story for why the council or board or whatever is doing something and the internal motivations behind it differ. I think what Dover, we saw a lot of that.
Yes.
Anything come out in discovery that suggested there was a more proselytizing intent behind this in its origin?
Not really. I mean, there wasn't a smoking gun. I mean, partly because discovery, there are actually like local legislatures, legislative bodies have certain immunities that like prevent you from sort of taking discovery on the motivations behind legislative acts. And even I mean, the Establishment Clause, at least under current law, does prohibit the legislature from acting with a religious purpose, but the Supreme Court has said, like, the way you ascertain legislative purpose is from it's sort of an objective inquiry into purpose based on publicly available materials. So there isn't anything, there's no, like, email where it's like, ha ha ha, we're not going to impose, create a theocracy in the town of Greece or anything like that. I will say, I mean, and, to be fair, I don't know that this town is, like, at the start set out to, like, impose Christianity on their citizenry. I think the town really just kind of assumed, oh, everyone in our town is a Christian, what's the big deal? Like, and I think another thing that tends to happen in cases like this is that once a complaint is raised, and then especially once a lawsuit is brought, then it oftentimes too just becomes a like, who the heck are these lawyers from Washington, D.C. telling us how to run our meetings? So, we've encountered that in school cases, I had a opposing lawyer of mine who represented another school, a lawyer who I had litigated against with one school district. We had then written a letter to another school district, and he said the superintendent called him up and was like, who the hell are these lawyers in D.C. telling us how to run our graduation? And he talked them down and made it clear we would sue them if they didn't relent. But I think it's partly just insensitivity or just an assumption that everyone's a Christian. It's partly then a desire to not have outsiders tell them what to do. But I do think there is still a kind of the third thing though. I think there is a significant resistance in some pockets to growing and increasing diversity, racial diversity, religious diversity, gender diversity, also changes in attitudes towards sex and sexual orientation. I think as you're seeing a lot of progress in certain respects, you're then seeing like the pushback from other pockets, and that I think tends to produce some of these results. So, I mean, the short answer to this, there isn't like a smoking gun document, but ultimately, although it does bar malicious purpose, the Establishment Clause is ultimately also concerned with effect, precisely because motive can be so difficult to unearth in many cases. Yes?
This has to be the last.
Okay. Final question.
I would have thought of a better question.
I'll rephrase it for you.
I guess it's useless to point out the hypocrisy to these towns that object to the Washington lawyers coming in when they accept free defense work from the Alliance Defense Fund,
Right.
ACLJ, from Washington, D.C.
Right. Now, I mean, to be fair, the town in Greece didn't actually say these Washington lawyers. It's more sort of me. I think I think that is something to affect. But you're right. I mean, when and like groups like Alliance Defending Freedom, which is the group that has advised the town, they go around the country sort of advising towns basically how to get away with. Yeah, I mean, I have another case, a case I'm litigating in the trial court in North Carolina, in which the town was doing something unconstitutional. We wrote to them. The town realized it had to fix what it was doing, but this group, Alliance Defending Freedom, advised them with, here's the alternative that will allow you to escape constitutional scrutiny, and now here we are in court.
Defending you for free.
They're defending them, we're suing them, but over this policy that this other national group gave to the locality. So yeah, it does happen a lot. I mean, you do see a lot of these groups, kind of recurring characters, and groups like ADF who do kind of have their own agenda and try to get towns to push the envelope